In the family law realm, ex-spouses are now blogging expressions of hatred for their exes, for their lawyers, for their judges, and for life in general. They are posting private writings from their marriage and from their relationships. They are posting writings which are being circulated to millions regarding their children and the relative child-rearing abilities of parents. They are posting photographs that no one should see. If y'all know what Flickr is, Flickr brags that they now contain 325 million photographs. We now have something called Google Street View, so that if I don't catch your image here, I may catch you on the street. We're all very familiar, I think, with Mrs. Smith, who's an unhappy divorce litigant in the state of New York, who has decided that she's going to go onto YouTube to tell hundreds of thousands of people about her poor plight. Brian, let's show the portion of Mrs. Smith calling her husband's secretary. This is what she's placed on YouTube.
I'm filming at the moment. We're doing a video for YouTube. I don't know if you know, but you know, Philip and I never had sex, but he's got Viagra and condoms and stuff here and porn movies. Just ask him what he wants me to do with them. Would you?
Wait.
Hmm?
You want me to ask him this now?
Yeah, just ask him what he wants me to do with the condoms and the porn movies and the Viagra. We're filming for YouTube. I've got a film crew here. We're in the kitchen. So, does he mind what I do with his condoms and stuff? We're just talking about, you know, the fact that there's no sex life.
Okay.
And that he's trying to throw me out of the apartment. And ask him if it's okay still if I'm going to go to London. Because, you know, I should be in London selling tickets for addictions.
Mrs. Smith has not stopped there, of course. That is a snippet from YouTube number 1. She's now recorded YouTube number 2. Has anyone seen it? In YouTube number 2, she rails not against her terrible spouse, but against divorce lawyers. There are new regulations proposed that will allow cell phone usage basically unlimited on airlines. Anyone concerned? We're concerned because it annoys us, but there's a privacy component as well. There's a case reported April the 15th of this year regarding a very loud, boisterous woman on a cell phone annoying other passengers because she was talking about an illicit affair she was having with a coworker. On and on and on and on. You get it. This is funny. You don't mind, etc. But amongst the crowd of annoyed passengers listening to this woman was someone that was clever. And this person had a cell phone. And this person took his cell phone and took a photograph of her and captioned it and placed it on the internet. For who to see? Her boss, her fellow workers, her friends. The ultimate revenge, perhaps. And that's the type of privacy you're going to see discussed in domestic relations cases in this country. On the home front, I guess I would say in Georgia, a lot of you are probably familiar with this poor soul named John Fitzgerald Page. John Fitzgerald Page was trying to say hello to someone by the form of a wink using Match.com. In his response to the woman that he was interested in, he listed his credentials. He was a Buckhead high-rise dweller. He was an Ivy League grad. He had a job in corporate finance. He told her about his workout regimen, his height, his weight, and then he inquired, rudely of course, about her weight. The unidentified woman sent a Match.com response back, which was the equivalent of, "Thanks, but no thanks. Our personalities do not match." That got Mr. Page fired up. Now, Mr. Page, remember, believes that he has an expectation of privacy having this discussion with this spurned potential lover. He sent her a scathing missive which can be read now at gawker.com. It accused this woman who sent merely a headshot and a thanks but no thanks of being out of shape. It said that I have many qualities that you're missing out on, including 8.9 on a scale of hot or not, that I'm a Mensa member, that I can bench press over 1,200 pounds, that I've had lunch with the Secretary of Defense, I've had an MBA from the top law school in the country, I drive a Beamer, which he spells B-E-E-M-E-R, convertible, and I have been in 14 major motion pictures. She was not amused. She sent this to Gawker, and by the time that 4 days had elapsed, it had 165,000 hits. And what Mr. Page said on his own website, which he's now posted, every single piece of my life has now been put up for scrutiny. An overnight internet pariah for sending a girl, calls her a girl, a personal email. Everything I've ever worked for in my life has been sullied in one day. That's the fate of Mr. Smith regarding his, what he believed to be privacy interests. I think one of the deeply troubling and interesting cases that you're going to be dealing with, again, we're talking national trends, comes by the way of the case of Gerardo versus Kransky out of Vermont that was decided January 14th of this year. And again, we can ignore the materials, they're in there. Let's talk about this case a little bit. This is a case in which there's a divorce case pending. And the wife learned during the pendency of the divorce case that the husband had, in preceding weeks, been posting certain blog entries on the internet. These entries included a chronicle of what defendant's counsel concedes is a thinly disguised, fictional account of their marriage. What happened in Gerardo was that the husband found the wife's diary after she left the marital residence. And what he decided to do with that diary, he decided that he was going to post a blog. She found out about it, and she went to the court, and they had this interesting standing order similar to what we do here. The order says that both parties are prohibited from harassing one another. So she goes to court in response to this blog during the pendency of her case and asks for an order that prohibits him from making any online statements about her. It asks that the blog be taken down, and it asks, in addition, that he be restrained and enjoined from communicating with her in any way. What's interesting is part of the blog said the following: the better use that I can make of the most intimate and personal details of their private lives will be spread from one end of the planet to the other and back again. He contained in his blog numerous derisive commentaries regarding her as a sexual partner, regarding her use of psychiatric medication, regarding the perceived paucity of her contributions to the marital estate. He tried to do this in a pseudonym kind of capacity, meaning this is not my real spouse, but he messed up a little bit by using her actual name a few times, using their actual home address a few times. Although he never correctly referred to his wife's lawyer by name, he simply called her Ms. Incompetent. As the trial court analyzed what it could or should do regarding these blogs, the court found that the blogs could be inaccurate. They could be defamatory. They could be inappropriate. However, with the exception of defamatory language, free speech, profane, irritating, and vexatious, does not violate the First Amendment.